Good afternoon, good morning, good evening, depending on what time zone you're in. My name is Suzanne Daly. I'm based in New York, and I'm going to be one of your facilitators today. I helped organize this webinar in my capacity as a member of the National Lawyers Guild International Committee and as a member of the Bureau of the International Association of Democratic Lawyers. I'm going to just proceed with a little bit of an introduction to talk a little bit about the two sponsoring organizations and give a little bit of context about this webinar, how it came to be, and what the goals of today's discussion are, or at least what we're hoping to be able to address. But first, I wanted to give Charlotte Cates, who will also be one of the facilitators, a chance to also introduce herself. Charlotte?
Hi all, and sorry for the delay in my comments. I reiterate Suzanne's words and thank you all for joining us today. As you know, this workshop is jointly organized by the International Association of Democratic Lawyers, as well as by the National Lawyers Guild International Committee. The International Association of Democratic Lawyers brings together lawyers and legal organizations from countries around the world. Collectively, its membership represents hundreds of thousands of lawyers. It includes the entire membership of the Arab Lawyers Union and has member organizations in nearly every continent in the world. The IADL played an important role. It was founded following World War II in the aftermath of the fight against fascism and in the development of international legal mechanisms, and it continues to organize today. And I think that many of the people that we're going to be hearing from today play a really critically important role in the ongoing work of the IADL to use international law to defend the rights of the peoples around the world. So with that, I'll turn it back over to Suzanne and just note that we're delighted to see so many people interested in having this conversation and addressing this critically important issue at this time.
Thank you, Charlotte. So for those of you who might not be immediately familiar with the National Lawyers Guild, we are a US-based organization with chapters around the US and in Puerto Rico. We are the oldest and largest progressive lawyers association in the US. And Charlotte and I and some of our speakers are active in the National Lawyers Guild International Committee, which is one of our most active, largest committees that is dedicated to using our knowledge, our expertise, our experience, and really our proximity to institutions as a way to expose and challenge US imperialism in all of its manifestations around the world through actions of militarization, economic actions. We have a great lineup today, and I wanted to sort of also give a little bit of a background of how this webinar came to be. We have been active, the National Lawyers Guild and the International Association of Democratic Lawyers are only two of many, many organizations and collectives that have been bringing attention to the use of unilateral coercive measures around the world in the form of economic sanctions and blockade, and organizing and advocating to expose their impact on people, to expose them as human rights violations, to expose them as legal violations, and also to contribute to building a movement that can challenge the use of these measures, but not just challenge the use of these measures in the context of recognizing them as human rights abuses and trying to build redress for that, but also in the context of offering what is sort of a necessary analysis that these measures are not just exploitative standing alone, but these measures are used to further an imperial agenda, to further sort of agenda that serve the interests of the United States and their allies. And we had been planning to actually facilitate a discussion around these measures and the ways in which our organizations and movements are challenging them for some time. And then with the onslaught of the current COVID-19 crisis, the pandemic, the health crisis, and the economic crisis, it became even more of an urgent matter. And so we're hoping today that we can talk about that political context that I mentioned, and we can talk about legal framework around these measures, not merely so that we can identify how they are violations and how they impact people, but we can identify opportunities for us to collectively challenge them through legal mechanisms and through other mechanisms. But we're hoping also that this webinar will be the first in many webinars, with future webinars perhaps not necessarily focusing as much on the legal conversation, but delving more into the political conversation and conversations around building anti-imperialist movements. And I'm gonna hand it back to Charlotte to add to that. I think you're on mute, Charlotte.
Thank you so much, Suzanne, for that important introduction to the work that is being done and to the framework which is guiding this panel and this discussion. The people that are participating today are engaged in so many levels in legal work, advocacy work, political work, and really organizing on a multitude of levels to confront unilateral coercive measures, which at its core is a critical aspect of confronting imperialism today and standing up against the war drive and standing up against the destruction of countries and societies and people that have been targeted by the United States and its allies, including Canada and many countries in the European Union. Because when we speak about unilateral coercive measures, we are definitely speaking about a violation of international law, and a tremendous violation of international law, an act of war, in fact. And this form of economic warfare is having devastating effects on the daily lives of people around the world. This has become, of course, ever more clear amidst the COVID-19 pandemic. And so, therefore, something that was already an urgent need, that is the need to confront unilateral coercive measures, to confront sanctions and blockades, and to collectively confront imperialism and this form of economic war on the peoples of the world, has become ever more urgent and an even more critical matter of life and death. As you noted, the deadly consequences of this policy have been seen previously, for example, in Iraq. And we run the risk of seeing that again, and the toll is already being taken. So with that, I want to turn it back over to you to begin this conversation with an amazing panel of speakers that we are very privileged to have with us today, to be part of this global conversation, this global movement building, and this global legal action for justice and accountability to confront the imperialist unilateral coercive measures that threaten peace and life around the world.
Thank you, Charlotte. I'm going to ask Micol Savia to be our first speaker. I'm going to read a quick bio. Micol Savia is the Transitional Secretary General of the International Association of Democratic Lawyers and the permanent representative of IADL to the United Nations Human Rights Council in Geneva, where she has delivered numerous reports and statements on human rights conditions and workers' rights around the world, and has been part of a number of legal delegations and fact-finding missions. She's a law graduate of the University of Turin, Italy, and has worked as a civil lawyer in Italy, working mainly in the areas of international law and human rights. She's also an active member of the Italian Association of Democratic Jurists, and is also a member of the European Association of Lawyers for Human Rights. Micol?
Hi, everyone. Thanks for organizing this timing webinar and for having me with you to discuss the issue of unilateral coercive measure, UCMs for its acronym. UCMs have always been an issue of great concern for the international community, but now in the context of the COVID-19 global health crisis and its economic fallout, with countries such as Gaza, Cuba, Venezuela, Iran struggling to provide their citizens with adequate protection, it is even more urgent to redouble our effort to have those illegal sanctions lifted immediately. I was asked to give a little bit of legal framework. I hope it's not too boring. So the term unilateral coercive measure usually refers to economic or political measure taken by one state or a group of states to compel a change in the policy of another state, or to use better to use the UN language, to coerce another state in order to obtain from it the subordination of the exercise of its sovereign right and to secure from it advantage of any kind. A variety of expressions are being used to refer to unilateral coercive measure. Anyway, in general, it would be better to avoid the use of term sanctions, as it implies that the sanctioning authority has some kind of jurisdiction on the sanctioned states, which is not the case. And it's also important to stress the unilateral nature of this measure, which itself raises the issue of their legitimacy. Unilateral coercive measure can be comprehensive or target. Target sanctions are also referred to as SMART due to the claim that they minimize collateral damage in terms of human rights impact, especially with respect to the most vulnerable group in the target country. Comprehensive sanctions aim at the whole economic or financial system of a country. They are indiscriminate by nature and have a devastating impact on the economy of the target countries. Their aim, declared or not, is clearly to create sufficient economic distress in the target country in order to incite the people to rise against their political leadership, regime change operation. As well noted by the former UN independent expert Alfred Esaias, modern-day economic sanctions and blockades are comparable with medieval sieges of towns with the intention of forcing them to surrender. Smart coercive sanctions, for their part, aim at a particular branch of production or a particular category of trade good, or might be broader but specific to a particular geographic area. There is also an increasing resort to sanctions such as asset freezing or travel bans that target individuals who are perceived to have political influence in the target country. In theory, smart sanctions' adverse impact on human rights should be more limited, but this is not always the case, as we will see. The Security Council has given up resorting to comprehensive sanctions since 1994, when it last imposed them on Haiti. Following this example, source countries, which are the countries imposing unilateral coercive measure, have generally been moving away from comprehensive sanctions to resort rather to smart sanctions. Though the introduction of financial coercive measures, such as ban on the use of the international financial system, is tantamount to the reintroduction of comprehensive sanctions. Likewise, when a number of different smart unilateral coercive measures converge on the same country, their summation may become a comprehensive coercive measure. And also, it must be said that when sanctions target a vital sector such as oil product export, such target measures come to affect, at least indirectly, the whole economy of a country. What all these measures have in common, apart from their unilateral and coercive nature, is that most current unilateral coercive measures have been imposed by developed countries on developing countries. There are a few examples of the reverse situation, such as, for example, the Arab oil embargo of 1973. The imposition of economic sanctions for political purpose is totally unacceptable from the point of view of international law. Coercion, whether military or economic, can never be used to seek a change in the government of another country. Such practice violates the most basic principle of international law. By signing the UN Charter, states commit themselves to respect the basic principle of peaceful coexistence contained in the Charter, and in particular, the right of people to self-determination, by virtue of which people can freely choose their political, economic, and social, cultural system, the sovereign equality of all member states, the principle of no intervention and no interference in internal affairs of other states. Under international law, states are also under the obligation to settle their international dispute by peaceful means, in such a manner that international peace, security, and justice are not endangered. Such peaceful means are listed in Article 33 of the UN Charter and include negotiation, mediation, conciliation, arbitration, etc. Article 2 of the Charter, paragraph 4, set out also out an obligation on states to refrain from the threat of use of force against the territorial integrity or political independence of any state. It is generally recognized that force, in the meaning of Article 2, should be interpreted as extending also to economic coercion, sanctions. With the Charter, we can say that the use of force in international relations have been banned forever. Under international law, dialogue and cooperation are not aspiration or options, but legal obligation. This is multilateralism. Under international law, the UN Security Council is the only legitimate body which may recur to the use of force in the collective interest, including by imposing economic sanctions, if this is needed to maintain or restore international peace and security. All coercive measures imposed outside the framework of the UN are unlawful and endanger the tenure of all the three pillars of the UN: peace and security, development, and human rights. It is indeed widely acknowledged that UCMs are a major obstacle to development. For all these reasons, numerous important UN resolutions and declarations call on states to refrain from imposing UCMs and to lift those already in place. Let me mention just few landmark documents. The Declaration on the Principle of International Law concerning friendly relation and cooperation among states, adopted unanimously by the General Assembly in 1970 on the occasion of the 25th anniversary of the United Nations, established inter alia that no states may use or encourage the use of economic, political, or any other type of measure to coerce another state in order to obtain from it subordination of the exercise of its sovereign rights. And the same article is included in the Charter of Economic Rights and Duty of States adopted by the General Assembly in 1974. The Vienna Declaration and Program of Action, which is the outcome document of the most important international human rights conference ever, adopted in 1993, calls on states to refrain from any unilateral measure not in accordance with international law that create obstacles to trade relations among states and impede the full realization of human rights. The use of UCMs not only constitute a grave breach of international law, but also entail to different degrees adverse consequences on the enjoyment of the human rights of innocent people, starting with the rights to life, health, medical care, adequate standard of living, food, education, work, housing, and development.
Nicole, I'm sorry, 1 second. We got a couple of requests to ask you to slow down a little bit.
Okay, sorry.
I'm not familiar with the legal terms. But I just wanted to let them know also that we'll be recording as well, so if people want to go back.
Okay, so, I'm very sorry because I'm trying to stay in the 10 minutes.
No, don't worry, we're not going to cut you.
Many things to say. I will speak slowly.
Thank you, Nicole. Thank you.
The use of UCMs not only constitute a breach of international law, but also entails, as I was saying, sorry, I'm repeating, to different degrees, adverse consequences on the enjoyment of the human rights of innocent people. The negative impact of UCM on the enjoyment of human rights has been widely documented and is not a matter of controversy. It is also well known that UCMs disproportionately affect the most vulnerable groups in society, including women, children, sick, persons with disability, older persons, as well as the poor. But at the end of the day, the reason why these sanctions are imposed is precisely to asphyxiate the economy of target country, provoke human suffering and political instability, and facilitate regime change. It is ironic that very often the proclaimed objective of UCM is the upholding of international law, human rights, and humanitarian law. Unilateral coercive measures are often said to be extraterritorial, because they are initiated by a country or group of countries and imposed outside their territory, their national territory and jurisdiction. The law imposing them may have extraterritorial effect not only on the target country, but also on third country in a manner that will coerce the latter to also apply the unilateral coercive measure on the target country. No compliance leading to heavy unilateral penalties. Seeking to impose the extraterritorial application of domestic law, it also constitutes a very serious breach of violation of the sovereignty of other states. For over 2 decades, the government of the United States has commonly applied the country domestic legislation, domestic sanction law to foreign persons and institutions. It has been reported that the UK also is in the process of introducing a similar legislation, while by contrast, the European Union is understood to refrain generally from applying any restrictive measure with having extraterritorial effect. The assumption that extraterritorial sanctions are unlawful is shared by a large number of countries, including the EU. Despite countless resolutions and documents adopted by the General Assembly, the Human Rights Council, the UNCTAD, and many other UN bodies, all urging states to refrain from promulgating and applying unilateral coercive measures, and despite the fact that very often such measures have been proven to be completely inefficient and even counterproductive, unilateral coercive measures continue to be promulgated, implemented, and enforced, with all their negative implications. According to the UN Special Rapporteur on unilateral coercive measure, 1/3 of humanity lives in countries affected in a way or the other by UCMs, and close to half of states members of the United Nations have at one time or the other been targeted by UCMs. The Human Rights Council, where I'm usually working, because as Susan says, I'm the representative of the IADL to the UN in Geneva, have been dealing with this issue for many, many years. Every year during the September session, the Human Rights Council adopts a resolution calling on states to lift sanctions, to refrain from imposing new one, etc., etc. And they also call states not to recognize extraterritorial measures and not to apply them. Source countries imposing sanctions, they don't participate in the debate. When they are requested, they don't submit any information, and they vote against all initiative. They defend the right to impose sanctions, and they say that anyway, the Council is not the appropriate forum to discuss such issue, because UCMs are concerned relation among states and not human rights, according to them. In September 2014, the Human Rights Council decided to appoint a new special rapporteur on the negative impact of UCM on the enjoyment of human rights, with the mandate of gathering information, analyzing trends, reporting to the Council, and promote accountability. Also, the establishment of the special rapporteur was adopted by vote, and with the opposition of all EU countries, with 14 votes against. The first special rapporteur was Idriss Jazairi, a brilliant human rights expert, former diplomat from Algeria. He made an excellent and very difficult work during all these years, presented various reports to the Council. He made country visits to Sudan, Russia, Syria, EU, European Union, and he was going to visit Venezuela, but unfortunately the visit was postponed because he was sick, and then unfortunately he passed away a few months ago. Now we have a new special rapporteur, a law professor from Belarus, Alena Duan. We don't know her because indeed she took up her function on March 25th. The special rapporteur made a lot of different propositions to advance in accountability and for unilateral coercive measure. Between various things, he suggests to draft a UN declaration on unilateral coercive measure. He called also for the creation of a UN or a consolidated central register, a UN register, recapitulating all UCM in force that would be maintained by the Secretary General, drawing on the example of the UN Register for Conventional Arms. This register should be made public, and source states should be invited to notify the Council all the unilateral coercive measures in force and their evolution. The Special Rapporteur also called upon members to consider submitting to the International Court of Justice a request for an advisory opinion on the legality or otherwise of the UCMs, especially under the angle of their compliance with human rights. For the General Assembly to take a decision to submit a request for an advisory opinion, a resolution adopted by a simple majority would be enough. There were something I wanted to say about remedies, but I will say after. Regarding the actual context, the current global health crisis is challenging all states. But the countries as Iran, Syria, Gaza, DPRK, Cuba, Venezuela, Zimbabwe, many other countries affected by UCMs are especially hard hit as they face extreme difficulties to obtain the necessary means to avoid the further transmission of COVID-19. During a few days, many special rapporteurs, a UN official, independent experts raised their voice, calling source country to lift sanctions or at least to suspend them. On March 24, the UN High Commissioner for Human Rights, Michelle Bachelet, recognizing that a number of sanctions impede medical efforts in Iran, Cuba, DPRK, Venezuela, Zimbabwe, called for sectoral sanctions to be eased or suspended. On March 26, the Secretary General, in its remark to the virtual meeting of G20 on the COVID-19 crisis, recognized that sanctions undermine countries' capacity to respond to the pandemic and appealed to waive them in order to ensure access to food essential health supplies. The UN Special Rapporteur on the Right to Food also called for the immediate lifting of crippling sanctions to prevent hunger crisis in countries hit by the COVID-19 pandemic. The new Special Rapporteur on UCM also urged the international community to take immediate measures to lift or at least suspend all unilateral sanctions that obstruct humanitarian response of sanctioned states in order to enable their healthcare system to fight the COVID-19 and save life. Even Pope Francis, during his Easter address live stream, called for the relaxation of international sanctions. Despite all this call and the call from civil society organizations, the US, just to show once more the respect for international law, is continuing to impose new UCMs, even now during the pandemic, against various countries, including Iran, despite the fact that Iran is experiencing a serious, deadly outbreak of COVID-19. US authorities show a concerning contempt for the United Nations, multilateralism, international law, but this is not new. Just think that the US, just few weeks after the signature of the UN Charter, which occurred on June 26, 1945, just few weeks after committing to refrain from the use of force to solve their international dispute, dropped 2 atomic bombs on the civilian population in Nagasaki and Hiroshima, but also on the same principle, of the UN. This is what we have to deal with. As Raji would say, this is the rule of the jungle against the rule of law. And of course, we have to stand with the rule of law and urge states to lift all UCMs against all countries. Thank you very much for your attention. And sorry for being long.
That's okay. Thank you, Micol. That was very informative and very important. As you were speaking, Charlotte and I were texting, commenting how we're both thinking about the question of how sort of when there are periods of momentum in these international bodies to challenge unilateral coercive measures, how that can be linked or is linked to popular movements also to challenge these measures. And part of the reason why we had this webinar in the first place was because there has been in the past year, in some respects, a new momentum to further to the popular movement to challenge these measures. So I just wanted to kind of keep that thought in mind, perhaps for the other speakers, and then also for question and answer if you want to kind of get back to that. So I'm going to introduce the next speaker, and Micol gave us sort of a very sort of important framework, and particularly of international law. And now we're going to hear about sort of the impacts of these measures in different contexts. We will not be able to cover all of the places in the world today that are impacted by unilateral coercive measures, but I think that hopefully in future webinars, we'll get to talk about the different contexts. And so with that, I want to introduce our next speaker, Nina Farnia. Nina is an Iranian activist and the past president of the San Francisco Bay Area chapter of the National Lawyers Guild. And she is currently a PhD candidate studying the relationship between law and US imperialism. Before returning to graduate school, she worked as a lawyer and was part of several legal teams for major racial profiling and employment discrimination cases, including Dukes versus Walmart and Vazaga versus FBI. Nina?
Thank you. Thank you, Suzanne, for the introduction, and thank you to IADL and the Guild, the International Committee, for organizing this event, and to Suzanne and Charlotte for bringing us all together. That was an excellent introduction, Micol. I really appreciated both the history and the legal aspects of sanctions. So I'm going to talk about Iran, and I'm going to begin and end with the same refrain, which is that all people of conscience must fight to end the sanctions against Iran, but against all these places. The sanctions regime in Iran is the most severe sanctions regime in the world today. But in the case of Iran, the sanctions are part of a broader, long warfare against Iran. The US has been engaging against various engaging in various destabilization efforts in Iran since 1979. The US embargo was imposed in 79, followed by the Iran-Iraq war, which was backed by the US, and then now the sanctions. And this all comes on the heels of severe underdevelopment that was imposed on Iran by the monarchy, by the Pahlavi regime, which was backed by the US. So Iran has been suffering under the thumb of the US for a very long time, and it has been surviving, and at times even thriving. But now, with the crisis of COVID, which comes right after the assassination of General Soleimani and the unfortunate downing of that plane, Iran has been suffering crisis after crisis after crisis. There have been floods in various parts of the country. There have been demonstrations throughout the country, everything indicates that the US and Israel have been involved in those demonstrations in various ways. They have both organic dimensions to them, but they also have foreign dimensions to them. So it's tough. Right now, the situation in Iran is very tough. I'm going to begin talking about the medical system and COVID, and then I'm going to pivot over to the economy. And to be transparent, the people that I spoke with in Iran, I spoke with a doctor and I spoke with some activists, asking them about COVID, the COVID crisis. Everybody told me, they talked a little bit about COVID, but they mostly talked about the economy and the effect of the sanctions on the economy, and as a result, on the social movements in the country and the social activity, basically. So the medical system in Iran is generally good. It's not great, but it's good, especially for preventative care and day-to-day illness. It's very easy to access care for day-to-day matters. Even when I'm there, it's very easy for me to access care. The doctors are generally very good, but for more serious and specialized care, the Iranian system is just not well equipped, especially compared to a place like the United States. And I can give you anecdotes of friends and personal anecdotes that are very interesting later on. Top of the line capital equipment like MRI machines and radiation technology and things like that are available in Iran, but they're available in private hospitals. And the medical system, I'll get to this later, has become increasingly privatized over the last few years. So these hospitals are very, very expensive. They're not accessible to the general population. A lot of people actually, a lot of the patients in these hospitals are actually people from abroad. So Iran has one of those medical systems where people come from other parts of the world to use its medical system because it's cheap for foreigners who are operating on the dollar, and it's a decent medical system. But in the public hospitals, which are available to the general public, this capital equipment is not in good condition and is not available. In terms of COVID, like the US, and other parts of the world, Iran is suffering from a serious shortage of ventilators, N95 masks, N99 masks, protective suits, and even cleaning supplies. Reports were coming out that in parts of the country, they had run out of basic cleaning supplies. There is a recognition on the part, unlike the US, there's a recognition on the part of the establishment that one of the ways to prevent COVID is to do broad-based testing among the population, but they have not been able to purchase enough testing kits fast enough. And the reason is that the banking system is completely sanctioned. No bank in the world can deal with Iranian banks without the threat of being penalized by the US. The other significant problem is that there's very little liquid currency available in the cash. Liquid currency is cash. Liquid currency available in the country as a result of the sanctions. People were hoarding currency for a while. People were having to go to the black market to get liquid currency. So there's all kinds of problems with the availability of liquid currency. This has made equipment and supplies even more expensive and harder to come by. So now I'm going to pivot over to the economy. Regular inflation as a result of the sanctions has already been incredibly severe. And just to give you an example, a few years ago, if you had $100,000 in your savings account, and not a lot of people do obviously, but if you had that much in your savings account, you woke up the next morning and 1/3 of it was gone because of inflation. So inflation was very severe, but this particular administration that's in power in Iran right now, the Rouhani administration, he's the president of Iran, is an incredibly neoliberal administration, and arguably the most neoliberal administration in recent memory. They've devalued the currency 3 times this year in order to encourage more trade with Iran and investment in the country, but the strategy has not worked because of the sanctions, and the people have suffered the consequences. And so I think this is one of the key points I want to make here, that like other societies throughout the world, Iran has an incredibly lively political system. Lots of politics, lots of politicians, lots of political actors. There are good politicians and bad politicians. There are better politicians and worse politicians, better administrations and worse administrations. There are political differences between the various political parties, between the social movement organizations, between unions, among the unions themselves, between different sectors of the economy and the government. It's just an incredibly vibrant society, and it has been for a very long time. Intellectually, politically, socially, it's a very vibrant place. And so this particular, what has happened, it's a crisis in a variety of ways, because the sanctions are at their most severe, and COVID has hit at a time when you have an incredibly neoliberal administration, more neoliberal than prior administrations, arguably. So this particular administration, like other parts of the world, right, we're seeing privatization in other parts of the world, is just not handling the crisis as well as it should. the Rouhani administration was a US-backed administration. It rode in on the waves of American support, largely by the Obama administration, because it claimed it would end the sanctions regime through the nuclear agreement. This means that people thought their economic conditions would improve, their livelihood would improve, and that they would be joining the global community. The advantage of the nuclear agreement, and I'm problematizing the nuclear agreement here. People talk about it as if it's a great thing, but I want to sort of problematize it. The advantage of the nuclear agreement was that it temporarily and theoretically, not actually, ended hostilities between the US and Iran. But it also had an economic objective, and that objective was to open up Iran to foreign investment. So when we think about political actions like the nuclear agreement, we can't just think about them in political terms. We also have to think about them in material terms and economic terms. And most people have not done this with the nuclear agreement. So this is one of two serious problems with the nuclear agreement. The first is that it was designed to open up the country to foreign investment. And the second was that it eliminated Iran's ability to defend itself. As I think folks on this call know, international relations scholars and politicians recognize that countries seek nuclear power as a deterrent to war and invasion. Most countries do not seek nuclear power to bomb other countries, except for the US. So they seek it to protect themselves. So the nuclear agreement had serious disadvantages for Iran. The Rouhani administration was already on a privatization kick. That's why it supported the nuclear agreement in the form that it supported it in. And now the sanctions have accelerated the privatization process that was already hitting Iran. There are less hospital beds than there were a few years ago. There are less public hospitals than there were a few years ago. There are more private hospitals and more inaccessible beds than there were a few years ago. There are less government-sponsored scholarships for university students. There are more private universities with very expensive tuitions. So the sanctions have severely exacerbated people's access to social goods. In terms of, how much time do I have left, Suzanne or Charlotte? I have more time left, presumably.
Yeah, you've got a few more minutes. Yeah.
Okay. So then I'm going to talk a little bit about arts and activism. As I said before, Iran is an incredibly vibrant society, especially artistically. It's produced some of the best art in the world, world-recognized art, world-recognized film. It has a very highly recognized international film festival. But as a result of the crises that have hit the country over the last year, a lot of this stuff has been shut down. And so this is another consequence of the sanctions, that what was once an incredibly vibrant society has now become less vibrant and less active. And it affects not just politics and not just the economy and not just access to medical care and education, but also arts, things like the arts. Recently, I heard this from some of my friends who are active there. They were organizing a the 8th biannual sculpture exhibition in the country. And it was going to be a collaboration between artists and sculptors, and it was supposed to be a very interesting collaboration and big deal. The Ministry of Art midway through ran out of funding. So they told the organizers of the biennial, you need to find private donors. And so they tried to find private donors, but ultimately were not able to continue because of the privatization and the sanctions. The other issue I want to talk about are the protests that happened in November as a result of the removal of subsidies on oil prices. There's been a lot of debate about these protests because people were carrying slogans, people were carrying banners and protests saying, "Down with the Islamic Republic." The Iranian government needs to stop supporting the Palestinians and start focusing on Iran. And for this was the first time. This was the first time that you see people in the street saying these slogans. There have been protests in Iran over various issues for many years, but this was the first time that you see these types of slogans. When I talked to people in Iran recently, they told me that it's clear. It was clear based on how the riots happened and the number of people that participated in the riots. There actually were not that many people that participated in the riots or that carried these slogans, that foreign intervention and provocateurs had a major role to play in these protests. And what they said was that the firebombing of very specific gas stations and very specific locations in the center of Iran indicated that the people doing this were highly organized and not social movements, not people who were interested in defending the people of Iran and in preserving their lives, but people who were interested in destabilizing day-to-day life in Iran so that they can destabilize the regime. So there are a few things that we need to do as people in the US. We need to demand an end to the sanctions, an immediate end to the sanctions, both because of COVID, but because of everything else that the sanctions have done to the country. We need to demand an end to and prevent war. And I believe the Trump administration is going to win this election. And if they win the election, the threat of war becomes very serious. We need to demand an end to war games with Iran, either in Iran or in Iraq or anywhere else in the region. And we need to demand an end to the use of Israeli and American provocateurs in the country, because the Iranian people need to be left alone to decide their own fate, to decide who they want their leadership to be, what they want their society to look like. They need to be left alone to make those decisions for themselves. And they cannot do that when they are under the gun of the US, both economically and physically.
Thank you so much. Thank you so much, Nina, for those important and incisive comments. We're going to, of course, discuss this more in the question and answer session. Now we're going to be moving more to a discussion of US sanctions on Zimbabwe. Now, of course, as Suzanne noted earlier, we know that US imposed sanctions are affecting, a third of the people in the world. They're imposed on 39 countries. So we know that this is not a situation that only applies in the case of Iran, in the case of Venezuela, in the case of Zimbabwe. I mean, there are many other critical examples such as Cuba, Nicaragua, Syria, the Democratic People's Republic of Korea. And we do want to return to those discussions in future webinars as well, which is something Suzanne noted before, but I just want to reiterate that point for people who may not have heard it before. In addition, I just want to remind everybody that the chat box is available. Your questions will be seen by the hosts of the webinar, so please don't hesitate to put your questions that you want to bring up to the speakers below down there, and express your thoughts or any questions that you want to see discussed later on during the webinar. And once again, this is being recorded. It will be available on the IADL and NLG International Committee websites and Facebook pages in the future. Now, with that being said, I want to turn the discussion to Roger Wareham, who is a lifelong political activist in the Black Liberation Movement and a founding member of the December 12th Movement International Secretariat. He is a former political prisoner, a human rights lawyer, and a member of the National Council of Black Lawyers. Since 1989, he has regularly participated in the UN human rights mechanisms in Geneva. He has been a leading advocate in the demand for reparations for the transatlantic slave trade and slavery and for the lifting of US sanctions on Zimbabwe. So we are honored to welcome today Roger Wareham. Thank you.
Thank you. And first I'd like to thank the IADL and NLG for the invitation to participate in this very important webinar. When we first went to I didn't include in my bio, when we first went to the United Nations in 1989, it was IADL who sponsored our appearance there. And then I've been with the NLG for a long time and was on a fact-finding mission to Honduras in 2009 after the coup against President Zelaya. First, I'd like to say that the first two presentations I thought were really, really, really good. One in terms of just setting the background and context for our discussion, and then in terms of the presentation of what's happening in Iran. I think it's important for people, the impression that the Western press gives of Iran as this closed, dead society, and Nina's presentation of the vibrancy of it and the type of dialogue and that goes on is totally counter to that. So I think it's important to get that out. Similarly, I'd just like to give a factual background, a historical background in terms of Zimbabwe and how we got to the point of these sanctions being first imposed in 2001. I think most people know that Zimbabwe fought an armed liberation struggle beginning in 1967, and in the latter part of 1979, they were at the point of seizing the capital, Salisbury, militarily. But at that point, there was a decision to really negotiate a political settlement because the frontline states, Zambia and Mozambique, who were supporting that struggle, were coming under increasing attack from the Rhodesian forces and from the South African forces, who were sending in planes and killing civilians. It became too much of a burden to ask that the frontline states hold on and suffer those kind of sacrifices. So there was a decision to hold a political negotiation, a political settlement. It was held at Lancaster House in London in 1979. And out of it came the Lancaster House Agreement, so-called Lancaster House Agreement, which provided for really a parliamentary democracy, a 10 to 20-year golden parachute for the white settlers who were allowed to be represented in parliament far out of proportion to their presence in the population, and also for there to being what they call a willing seller, willing buyer agreement for the Zimbabweans to recover the land that had been stolen from them, 80, 90 years before that. That was negotiated under Prime Minister Thatcher and President Carter, I'm sorry. What the United States had to do with Zimbabwe makes no logical sense. This was one of those kith and kin arrangements that the British needed a backup, and the United States was going to provide it because we're all kith and kin. We come from the same perspective where the United States is the child of settler colony. And so that was their backup. The agreement was that the money that was going to be given to the settlers whose land was being taken from, whose stolen land was being returned to people, will be provided by the United States and the UK. And that the only money that the Zimbabweans might provide would be provision for any improvements that had been made on the land, but they were not going to pay for the land at all because their position was, it's our land and you stole it. When the time came for that arrangement to be made and for the money to be put forth, the United States, then under Prime Minister Blair and President Clinton, said, well, there's no money, and besides that, that was an arrangement made by a prior prime minister and a prior president, as if there's no sovereignty that goes across from one administration to the other. They basically said, we're not going to do it. The war veterans in Zimbabwe, whose position was, we fought this war for land. We didn't fight it for, for a parliament, and that we fought it for the land, began to reclaim the land willy-nilly. The government, President Mugabe, the head of ZANU-PF, said we're going to do this in an organized way, and they instituted a land reform program to return the land to the indigenous people of Zimbabwe. If you want to get an idea of when that program began, if you go back to past issues of the Western press, you will find that from 1980 till 1998, 99, President Mugabe was hailed as the model African president. He was the model of democracy. He was the model of reconciliation. He was the George Washington of Zimbabwe. And then at a certain point, almost to the day when they announced the land reform program, he went from being George Washington to being called the Black Hitler. The only thing that had changed was that the Zimbabweans were exercising our right to self-determination and to reclaim the land that was stolen from us. And it was from that point in time that several different things happened. The white farmers formed an opposition called the Movement for Democratic Change. That became the so-called legal opposition in Zimbabwe. They placed a black trade unionist in charge of it named Morgan Tsvangirai. The United States passed the Zimbabwe Democracy and Economic Recovery Act of 2001, which, for those of people who are familiar with the United States, will find that two of its co-sponsors were a very odd couple. One was Hillary Clinton, and the other was Jesse Helms. And for those not familiar with the United States history, Jesse Helms was one of the long-time racist senators from the South who upheld segregation to his dying day and fought it and was a dyed-in-the-wool racist. They came together to sponsor this bill. This bill, the thesis of the bill, of the Zimbabwe era, is that there's no democracy in Zimbabwe. Although up until that time, they had regularly scheduled elections that there had been no problems for in the West, but that there was no democracy in Zimbabwe, and that until democracy was restored, that there were going to be sanctions taken against Zimbabwe, bilateral loans, international loans, that the United States would use its influence, which was almost total, in the International Monetary Fund and the World Bank to deny them loans. That no loans, that the United States would funnel money to organizations that they considered democratic, and that when the President of the United States decided that democracy had been restored, then they would lift all these sanctions. The Bush administration said shortly after they instituted Zadira, they said, "We do not see President Mugabe as a democratically legitimate leader of the country. We are encouraging the biopolitics of Zimbabwe to go forward and correct that situation." Now that language sounds very familiar to what the United States said a few months ago about Guaido in Venezuela. It's almost the exact same language around how they determine who's the legitimate leader. So there were no bilateral relations, no bilateral loans. A year later, the United States, the government, the president started to issue executive orders targeting specific individuals and specific companies that people in the United States could not do business with, or they would face sanctions or fine themselves. The tactic was to make the economy scream, which is an old tactic that the United States first articulated in Chile in 1973 when they moved to overthrow the Allende regime. And the goal was regime change. That's what the goal was then. That's what the goal remains today. So they have what they call these targeted sanctions, and that's a myth. That's a myth. The sanctions, as has been articulated earlier, and I'm sure will be later, the sanctions do not really get to the so-called targeted individuals. The sanctions are to undermine the economy and cause so much unrest that the population will rise up against the elected government, blaming the elected government for the problems, as opposed to the Western countries who are benefiting from it. So it has meant that over the years, Zimbabwe has had to face, there's been almost a 20-year drought in the Southern African region, that whole region. They've had to face that with a lack of resources. They've not been able to get the type of heavy equipment they need to do agriculture, to have the type of chemicals they need to prevent preventable diseases like cholera. The economy had reached such a low that by 2008, when the recession was going on in the Western world, Zimbabwe had probably the highest inflation rate that had ever been seen in history. I was there that year and got off the plane and exchanged a couple of $100 US, and I was an instant millionaire because it was just, the money was almost worth it. So the idea was to almost destroy the economy, but they were unsuccessful in doing that because ZANU-PF, despite the attempts of the Western propped up MDC, still had support amongst the people. The country was which mainly 85% rural, and that's where ZANU-PF's basis is. So by 2008, and let me just say this just for the record, when the land reform program began in 1999-2000, 4,000 whites had 85% of the best land in the country. Those are 4,000 whites out of a population at that point of about 12 million people. And that meant that the majority of the population was left to deal with the worst land, although they were the indigenous people of the country. So let's bring us up to 2018. In 2018, there had been a change in government, not a change in government, I'm sorry, a change in leadership. President Mugabe had resigned. President Mnangagwa was the interim president. He came up for election in July of 2018. They took all of the steps that the West had said was necessary in terms of transparency and access. There were Western observers from the United States, from the UK, from the EU, from Russia, from around the world there. And we were there also, our organization, we were observers. I was an observer. And I think it was universally recognized, except for maybe the EU, that the election was fair and free. And even the lead up to the election, all the different parties had the ability to participate fully. And so as the election results came in, it was clear that ZANU-PF had won overwhelmingly because it was a national election on the level of the parliament, and that President Mnangagwa had won a majority in terms of the presidential election. A day later, maybe 2 days later, there was a disturbance of people from the opposition who went through Harare, the capital, and some other parts of the country, and started burning buildings and businesses. And then the government was forced to respond. And in that response, and it's still not clear. I mean, there was an investigation conducted. I think 2 people were shot, or 3 people were shot and killed. And that then became the issue. The issue became that the election was no longer legitimate because they said that the Zimbabwean government had over-responded. And once again, you get the question of that I think Nina had raised around the provocateurs that existed in Iran when these demonstrations happened, and why it happened, particularly at that point in time. A week later, President Trump signed an amendment to the DERA, which even further ratcheted up the demands, or part of the demands were then to relook at the question of the land that was taken from whites and the reimbursement they had or had not received, and to revisit that and to open that back up again, although the government's position is that the land reform question is not up for discussion. How do we move forward with this? And how has Zimbabwe survived to this point in time? One is they adopted a look east policy, that they began to get aid from China and India, aid that came unattached with strings, and aid that was geared towards developing their self-determination and their ability to develop. Some of the EU countries are starting to back off because it's very clear the steps that have been taken by the administration under President Mnangagwa are the steps that they had said were necessary for them to consider reinvestment.
Roger, if you could just wrap up in 1 to 2 minutes, then we can continue the conversation. Thank you so much.
Let me wrap up with this.
Absolutely.
The question of how we move forward is on many different levels. One is in the region of Zimbabwe itself. The South African development community has taken a position around lifting the sanctions. In the United States, we have a campaign to pressure the Congressional Black Caucus to take a position against the sanctions. And then on a larger level, in terms of the United Nations and those institutions, it should be brought up at the Security Council. It should be brought up in the International Criminal Court. It should be brought up in the International Court of Justice. So I'll leave it at that and deal with any questions that people have. Thank you very much.
Thank you, Roger.
Great. Yes, thank you so much for that extremely informative, interesting, and engaging presentation. And now we're going to turn our attention to another country that is being targeted by US sanctions and other regime change efforts. We're very honored today to welcome Cristóbal Cornieles from Venezuela under sanctions. He is a Venezuelan lawyer and a human rights researcher. He works with organization Jurists and the Venezuelan Association of Jurists, which is a member association of the International Association of Democratic Lawyers. And we are very pleased to welcome him here today. So with that being said, I will turn it over to Cristóbal.
Hi, good morning, good afternoon. I would like to thank Charlotte, Suzanne, and especially Micol for the invitation to participate in this webinar. I would like to start by sharing a presentation. Well, I would like to remind some of the statements that have been issued by the US Department of State in recent years. It's important to listen how they speak to the Venezuelan people. The pressure campaign against Venezuela is working. The financial sanctions that we have imposed has forced the government to start falling into default, both in sovereign and PDVSA's debt. PDVSA is a state's country that produces all the oil in Venezuela. And what we are seeing is a total collapse in Venezuela economy. Then our policies work, our strategy works, and we will keep it. We must treat this as an agony, a tragedy that will continue until it finally reaches an end. And if we can do something to accelerate, we must do it. But we must do it with the understanding that this will have an impact of millions of people who are already having difficulties in finding food and medicine. We cannot do this and pretend that it will not have an impact. We have to make a hard decision that desired and that justifies these severe punishments. These are the statements, the declarations of the US Department of State. Well, that's why we believe that the blockade is illegal, immoral, and unjust. Maybe Venezuela is the recent blockade in the world against Venezuela. It started in 2014 in December when the US Congress adopted the Act 113-278 that prohibited any US citizen or person under US jurisdictions to make any economic transactions with Venezuela, with the Venezuelan government. And it provides severe sanctions to those who break that prohibitions. This law is similar to the law applied to Cuba, the Helms-Burton law. It's just a little more modern in its elaboration. This act established specific prohibitions to two organisms that are very important in our country. The Central Bank of Venezuela, that's the maximum authority for state monetary policies, but also administrates the international reserves of Venezuela. And to Petróleo de Venezuela, the PDVSA, that's a main state company that has a monopoly of the production of oil and that generates more than 95% of the revenue of the incomes of the country. Until now, Venezuela, the people of Venezuela have been victim of 72 formal unilateral coercive measures, UCMs, and unlimited forms of applying these 72 UCMs. Mainly they come from the US and Canada and the European Union. During the Obama administration, there were only issued 2 of these UCMs. But when Trump became president of the US, he had applied more than 52 UCMs in the last 3 years. As Roger said, it's a myth that the GCMs are only targeted sanctions, no? Most of the sanctions against Venezuela, formal sanctions, have been applied against enterprises, business, private business, ships and aircraft. I would like to just expose some of the impacts of this blockade in our country. Right now, the largest corporation that Venezuela has in the USA, that's Citgo Petroleum, that withholds 3 refineries, 6,000 service stations and 48 storage distribution terminals. It's been undertaken by the U.S. government. Since 2016, Venezuela hasn't been able to receive the profits from this enterprise that's Venezuelan owned. The losses of these actions are estimated in $18 billion of the Venezuelan people that right now are under the administration of the government of the U.S. This is a graphic that shows the production of oil and the incomes of oil production since 2015 to 2019. Only to explain and illustrate the impact of the blockade in the main source of income of our country. By 2013, we had an income from oil approximately of $42 billion every year. Right now, in 2018, that's the last information published by the state, we have less than $4 billion in income from petroleum. Just to illustrate the impact on food and medicine, we used some information of the MIT Global Economic Observatory. By 2014, we imported 34% of our medicines from the US. That importations were stopped by 2015. In only 1 year, we lost almost 50% of the importations of medicines and supplies for health due to the blockade. With food, it was almost the same. We imported most of our food from the United States and from Canada by 2014. By 2015, this blockade prohibited us to buy food from the US and Canada. But we also have been, we had a lot of troubles to acquire medicine and health. Basically because the international financial systems enables us to use our own resources to buy basically food, medicine, and supplies for industry. You can, in this graphic, you can see how the imports of food decreases between 2014 and 2018. You can see that the decrease was almost to the half of the food we needed as a country. But the blockade also has impacted in the human mobility in the migrations process. Due to the blockade, during the last 5 years, almost 3 million of people, 3.5 million, has migrated from Venezuela, basically because of the economic situation. Right now, the Venezuelan state has $7 billion in 40 international banks. and we're unable to move it, to administrate it, to use it because of the US blockade. We estimate right now that the losses due to the blockade are almost around $130 billion in the last 5 years. Well, right now, the United Nations are starting to make statements against the sanctions imposed to Venezuela. The special report on the negative impact of the unilateral coercive measures on the human rights, Idris Yazada, that died recently, stated that sanctions would aggravate the situation of Venezuelan people who are already suffering the effects of devastation, of a devastating inflation and a lack of adequate food and medicines. Also, Alfred Desayas, that was an independent expert on the promotion of democratic and equitable international order, stated that the UCMs have aggravated directly and indirectly the shortage of medicines such as insulin and antiretrovirals, which has caused delays in the distribution and caused worsening in numerous cases of death, which constitutes a consummation of crimes against humanity. And recently, the High Commissioner for the Human Rights stated that sanction affects most vulnerable and do not contain sufficient measures to mitigate the impact on Venezuelan population. The blockade against our country, it's not only an act of war, it's also a crime against humanity, at least as it's established as in the Article 7 of the Statute of the International Criminal Court. And recently our state presented a demand against President Trump at the International Criminal Court to establish responsibilities for the blockade against our people. Right now, we would like to ask everyone that has a little bit of conscience and that's compromised with the human rights to support this action in the International Criminal Court. In fact, from the Venezuelan Jurists Association, we're going to present in the next weeks new information to support this action taken by the state. And we invite you to support our actions. Thank you.
Thank you so much. Thank you. Thank you, Cristóbal, for this informative presentation. Thank you for this informative presentation. And now we have two more speakers, and we're very pleased to go to both of them. And so we want to make sure that people stay on to hear our final two speakers, who are Raji Sourani from the Palestinian Center for Human Rights in Gaza, and Raji is going to be our concluding speaker. So right before Raji speaks, we're going to invite Marty Schmidt, who is a retired labor and employment lawyer, a former college professor and union organizer who works on the right to health, to speak next. She recently wrote a report for the National Lawyers Guild, International Association of Democratic Lawyers, and the People's Action for Rights and Democracy Institute on how financing affects the right to health care in the United States, which was submitted to the 2020 Universal Periodic Review of the United States at the UN Human Rights Council. So with that being said, I'd like to welcome Martha Schmidt. Marty, can you hear me?
Yeah.
Great.
Okay.
Perfect, we can see you now.
Okay, good.
If you can move it down a little bit, that would be great, but otherwise it's good.
Is this okay?
Yes, thank you.
Okay, so I'm going to talk a little bit more about the basic international law issues involved in the unilateral coercive measures, and skipping over the things other people have have already touched on. Thank you so much for inviting me.
Margie, I'm sorry, if you could just move down your video camera just a tiny little bit so that your face is in the center. Perfect, thank you.
Okay, great. So just one, we already have seen this definition. It's from a Human Rights Council resolution, but I just also wanted to point out that unilateral coercive measures can precede and coexist with the use of military force. I think it's something we might want to be looking at. Just the sources of international law which prohibit unilateral coercive measures are defined by the statute of the International Court of Justice. And so those sources are things like treaties, customary law, general principles of law, judicial decisions, and teachings or reports, for example, of legal experts. Also, I want to mention that the US Constitution gives priority to treaties and recognizes customary international law. We have the Supremacy Clause of Article 6, Paragraph 2, which says, all treaties made or which shall be made shall be the supreme law of the land. Also, treaty making is reserved for only the federal government, and Article 1 also recognizes customary law, that is the law of nations, in its powers of Congress to punish piracy and felonies on the high seas. The US did ratify the UN Charter in 1945. In fact, it was one of the founding members of the United Nations and was an enthusiastic supporter of this international system, which proclaimed that international disputes shall be settled by peaceful means, and that all members should refrain from the threat or use of force against territorial integrity or political independence. And I might note, or in any other manner inconsistent with the purposes, which include the purposes of the UN to promote human rights. Another treaty the US ratified in 1951 was the Charter of the Organization of American States, the OAS Charter, which has more specific language even than the UN Charter about unilateral coercive measures. As you see here in Article 18, the prohibition is against not only armed force, but also any other form of interference or attempted threat against the personality of the state or against its political, economic, and cultural elements. Very comprehensive statement. And Article 19, the prohibition specifically of coercive measures. It also says no state may use or encourage. So that would apply to the US's involvement in bullying other countries to conduct threatening foreign policy against states like Cuba, Venezuela, and so forth. You see here, the focus here is on the sovereignty of the state, which is pretty typical of that time period. Then we have statements in our human rights, the Bill of Rights, International Bill of Rights, the Universal Declaration of 48, and the two covenants. The US has ratified the International Covenant on Civil and Political Rights. It still hasn't ratified the Economic, Social, and Cultural Rights Treaty. Nonetheless, much of that is customary law. But as you'll see in these articles 28 and 30 in the declaration, that people in the states of the UN are entitled to social and international order which protects human rights, and that no state is permitted to engage in activity or perform acts aimed at destruction of human rights. There's also the common article of the two covenants, which talk about the right of a state to freely dispose of its natural wealth, which is in other instruments, but here it's interesting that the focus is on the state's ability to provide for its people. That is, in this statement, in no case may a people be deprived of its own means of subsistence. And then just echoing what Micol said earlier, that the only sanctions that are permissible through the Security Council are addressed under Title VII of the UN Charter, are addressed in General Comment number 8, which has to do with the implementation of the Covenant on Economic, Social, and Cultural Rights. And in that general comment, it's made very clear that any kind of sanctions has to still address respect for economic, social, and cultural rights. That is non-derogable. Micol mentioned this resolution, a very important statement supporting the treaty language of the charter, and basically confirming the, elaborating a little bit on the on unilateral coercive measures, and they can be economic, political, or other kinds of measures. So it's extremely comprehensive in its scope. And you note in the last sentence also that states are prohibited from organizing, assisting, fomenting, financing, inciting, or tolerating activities directed toward the violent overthrow of the regime or interfering in the civil strife. And I note that Roger has also referred to this, and other speakers, that we have the problem of the United States using unilateral coercive measures directly and indirectly, sometimes through the National Endowment for Democracy, basically other mechanisms besides what we'd call economic sanctions. Just mentioning the long economic warfare, if we're going to use that term in a loose way, against Cuba, as exemplified by the embargo, 28 years, and basically every year the world community demonstrating to the United States that its practices, its policies are illegal under international law. Also, the report of the UN Secretary General back in 2006 addressing unilateral coercive measures, which might be a helpful source for us to include. Then there's also international court decisions which have a bearing on the legality of unilateral coercive measures. And I just mentioned this important decision in Nicaragua versus the United States from back in '86, which was the Reagan administration Contra war, involving some of the same characters we see in the Trump administration, John Bolton, Elliott Abrams. In that case, the court used both the UN Charter and the OAS Charter, as well as that General Assembly resolution that you've been provided a couple of times now by several of us. But what was interesting here, because a lot of the aggression was acts involving military force, like mining the harbors, the court also did make a statement regarding other forms of interference, that the prohibition extends beyond armed force to any other form of interference or attempted threat. Then, as Micol mentioned, the very important Vienna Declaration and Program of Action. And I think here it's useful for me to add that the focus is also on trade relations among states and the relationship between trade and human rights. And there is an entire area of international trade law in which the United States is grossly violating underlying principles such as most favored nation status, most favored nation, and the idea of free trade, which is so broadly proclaimed but not followed. And just to recap on some of the assumptions that we see in these treaties, resolutions, declarations that prescribe unilateral coercive measures, we have a recognition of the international legal community that national sovereignty is a political idea, but it's also an idea about protecting state resources. So it involves issues of governance, borders, and global economic rules. That sovereignty does include the capacity of a state for economic subsistence. Obviously, this has been said before, that colonialism and imperialism have prevented states from becoming truly sovereign and exercising the rights of sovereign. Therefore, the need for international law mechanisms to exert special protection and check violations. And that, as I mentioned, with the trade law, but unilateral coercive measures violate many areas of accepted international law. We talked about a human right to development. We've talked about trade. There's areas, there's the international law of development. There's human rights law. There's international humanitarian law. There's law of the sea. And I just wanted to also mention, as the previous speaker, that the issue of international criminal prohibition. So what I've been talking about is generally not criminal law prohibitions against unilateral coercive measures, but clearly that's where the evolution is going. And what we're looking at is, with massive human rights violations, the idea that a state or individuals from a state engaging in unilateral coercive measures could be found guilty of crimes against humanity without there being any kind of accompanying war crimes. That is, there doesn't have to be, the US would actually make the case that Venezuela has against the US in the International Criminal Court would be made even stronger if the US is stupid enough to engage in a naval blockade in the next weeks. But it's not necessary to have a war crime as well. I think several people have mentioned both Desaias's and Jazari's statements and contributions to defining unilateral coercive measures as violations of human rights and international humanitarian law. Another point I think that Desaias makes, which might be of interest for us to talk about or to take away with you, is this whole notion of the use of or the manipulation of public opinion through fake news, aggressive public relations, and pseudo human rights rhetoric, so as to give the impression that a human rights end justifies the criminal means. So I just call your attention to the, I guess what I'd say is the ideological legal battle that we face. So Charlotte's talked a bit about the countries. There's, I think, 39 states. There are many states that people weren't aware of. You know, when you start working with peace and justice groups, you realize that people are only aware of a few of the targets, and so many countries are affected in such profound ways by the actions of the United States government. So these are my questions, some of my questions as a contribution to the discussion, but just, you know, a few of these, I mean, the question about whether unilateral coercive measures are being used instead of military force as a more effective way to dominate, I think is worth having a discussion about. Does the US public believe unilateral coercive measures are illegal? And who's benefiting from these? Are they directed only at states which have natural resources, which US corporations covet? Are unilateral coercive measures being used because the US is growing weaker economically? Is the rest of the world going to reject the US dollar as a cornerstone of the global economy? And what consequences would there be from that? And what's the best strategy for challenging the massive violations of human rights? Thank you very much.
Thank you so much, Marty. That was an excellent presentation. And I think ending it with those questions is very important, and particularly the ideological question. And I think that it's been sort of the experience of many of us that that ideological battle is present everywhere, including in our so-called progressive communities. You know, we have many, many people who work sort of in this framework of upholding human rights, but still sort of are kind of driven by these ideas that come out of a kind of American exceptionalism and sort of ideological view of Western values, and that's kind of one of the walls that we need to penetrate. So I'm going to introduce our final speaker for the day, Raji Sourani, who is joining us from Gaza. Raji, we're very happy that you were able to join us today. We know that it's evening for you as well. Raji is the founder and director of the Palestinian Center for Human Rights, which was founded in 1995 and has gone on to receive international praise and recognition for its research and advocacy role on the Israeli occupation of Palestine, as well as its direct intervention on human rights issues in the Palestinian territories. Raji is also a practicing lawyer and counsel in the International Criminal Court representing Palestinian victims. In the course of his work, he has been imprisoned on 6 occasions, the longest for a period of 3 years, and was adopted by Amnesty International as a prisoner of conscience in 1988. He is also a member of the Executive Committee of the International Commission of Jurists, Vice President of the Fédération Internationale des, I can't pronounce, FIDH, sorry, I can't pronounce the French very well, and President of the Board of Trustees of the Arab Organization of Human Rights. Thank you, Raji.
Hi, Raji. We can see you. You're muted though.
Raji,
Sorry.
You're unmuted.
Do
Raji,
you hear me?
yes,
we can
hear you
you
now.
Thank
Okay.
you.
Thank you so much, Susan. Thank you, Charlotte. And I'm happy to join you and be invited to this webinar. I don't want to talk too much legally. I have quite a lot of things I need to say actually in this regard, but my colleagues, covered that very well. And I don't think the reason we are having this webinar to talk about, you know, the legal definition and the legal qualification of the blockade. Gaza, for example, has been for the last 14 years under this blockade. And this blockade, its impact in simple words, ugly, disastrous, and criminal. We have 65% unpaid and unemployed. We have 90% under poverty line. and we have 85% of the population who depends fully on UNRWA rations and food distribution. Effectively speaking, we are shifted to be nation of beggars, and Gaza shifted to be sort of animal farm, international community dumping to it some food and medicine. And that's why this is disastrous in its impact, in its effect on the life of civilian population, basically, because actually the siege do affect and impact per se the civilians who should be protected at the time of occupation. And that's what international law, international humanitarian law, all about. More, that's why even before this corona crisis, we have total collapse of the medical system in Gaza. We have incredible shortages of medicine, equipments, doctors, and more. We have a real serious problem as well of those who died as a result of lack of movement for the patients. They are unable to receive developed medical care, or because of the equipments and medicine were denied, and because they were not able to live outside to receive developed medical care. Yet we don't have anyone in Gaza died because of corona or COVID-19, but we have hundreds who died because of the siege. And that's why all international human rights organizations, with no exception, whether in Human Rights Watch or Amnesty or FDH, ICJ, Euromed Human Rights Network, and all respected bodies, needless to say, National Lawyers Guild, the US or IADL, all of them, I mean, condemned in a clear-cut way. Not only them, but as well UN bodies also said the same thing. Special rapporteurs on the question of Palestine and for the occupied Palestinian territories, and the special rapporteurs in different aspects, you know, said in a clear-cut way, tens of resolutions has been taken. So legally, it's not an arguable issue. It's simple, it's clear, it's direct, and that's when we even went to the ICC. We as a Palestinian, one of 4 submissions, basic submissions to the preliminary investigation committee, which was formed. We submitted one of them about the blockade, which described in simple words at the ICC Rome Statute as a crime of persecution and a crime against humanity. So talking about the blockade legally, it's clear, it's obvious. The problem is the political will of the international community. I mean, that's the real problem. The problem is the US, which is doing the rule of jungle. The problem is Europe, which is not able, I mean, to act in a proper civilized way and act and react and apply the rule of law as it should do. And they with Iran, with Palestine, with Venezuela, and with other countries. They just act as the old Romans, I mean, dead in old Rome. There is law for masters and no law for slaves. And that's why, I mean, you know, they don't talk too much from legalistic, I mean, point of view about this. At the time of Corona, COVID-19, this all changed, I think, and I hope, and what's happening, what we are watching now on Gaza precisely. We have destroyed medical infrastructure here. We don't have access to medicine, I mean, as we need. And the occupation control everything from A to Z. That's why we are just expecting the unexpected. And if it's here, it will be disastrous by all meaning and standards. The siege killed many of us. Corona didn't yet, but I'm sure if it arrives here, it will be a real disaster for Gaza precisely and Palestine at large. While this coronavirus doesn't know nationality, religion, political affiliation, country, sex, I mean, it will hit everywhere. Now, having said that, I'm contacting a lot of friends in Palestine, in the region, in the world, and quite a lot of questions, tens of questions, hundreds of questions are raised. People right now, yes, obsessed of tackling, dealing, and trying to have an end or control for this coronavirus. But meanwhile, I mean, a lot of questions are raised. For example, capitalism. I mean, what about it? US with all its mighty was not ready, having no even information about this coronavirus, COVID-19, and they were not ready, I mean, to tackle with it and deal with it. Same thing happened, I mean, in Europe. What's the role of the state? The role of the capital state? Are they going, I mean, basically, a new liberalism based on two pillars. One, individual rights, and the second, not intervening in the rules of the market. What's happening? Full intervention by the states, taking over and intervening in very bold, unprecedented way in history, in all aspects, with no exception, and at the same time, individuals' rights, I mean, very, very questionable, and that's put a very, very basic and very big questions where we are heading with this coronavirus and how the world will look during and after. This won't affect only individual rights, won't affect only the the market per se, but it's affecting as well the social economical dimensions. Not in US, not in Europe, but in the whole world. I think, you know, we will be before and after something different. I mean, the world will change, and quite a lot of changes will happen. Now, the changes can be very, very negative, and changes can be very, very positive. Changes can be like what Trump said: I'm happy and ready to steal masks and respiratory systems if it's needed for the American people from anywhere, and US has the priority. But others, I mean, say, no, I mean, we have to be collective, and we have to face this collectively. This is not for one country or two, everybody, I mean, humanity should face that. Yesterday, US punished World Health Organization at this time, and they are major funders for WHO, and they stopped funding them. They suspended their funding. And WHO in real dilemma. Some said, no, I mean, we'll jump and try to help WHO and to bridge this problem because they have leading role in confronting this. Now, while we are talking about COVID-19 crisis and its consequence and how the world will react, I mean, on philosophical, ideological, legal, international relations, political questions, I mean, we have to be in the picture, I think, right now to say basically two things. One, siege and blockade is a crime. Should end long time ago, not today, but it's about the time to have an end for it and make people able, you know, to confront. They paid and suffered years before that, though they were victims of discriminate illegal persecution, I mean, by those who imposed this. And on the other side, how we make this world better. I mean, through criticizing the ugly, unaccepted policies, which was practiced, I mean, by these colonial and racist countries towards, I mean, those countries, I mean, not per se, you know, having this siege and blockade on them, but other practices as well. We want, I mean, to be real in confronting this crisis and try to have an end for this crisis, which will affect the humanity at large. But at the same time, we have to open our eyes and be critical. This is not be used as well to violate more individual rights and to violate more collective and people rights at large, and make, you know, in a way, international law, international humanitarian law more human and making people everywhere, I mean, with this suffering of this crisis. I'm not trying, I mean, to draw up a black picture or pessimism, but we have to be realistic. People everywhere obsessed fully, really, of what's going on, but we have to use the good in us, the good potential we have, the tools we are having right now to raise really, I mean, our voice that these policies, which was practiced on the international level, among other things, I mean, this illegal, inhuman blockade should have an end and make, you know, the world much better and much happier for the humanity. Thank you, Susan. Thank you, Charlotte. This is, I mean, what I wanted to say.
Thank you, Raji. Thank you very much. And actually, thank you to all the speakers and to everybody who joined us today. We received some questions. Charlotte and I received some questions directly sent to us, and we think perhaps the best way to proceed is that we'll share what those questions are, and then we'll just open it up for speakers to give their last comments and answer whichever questions might be directed to them. Charlotte, do you want to start?
Sure, yeah, I'll start with the questions that I have. You know, we really appreciate everyone's time. We know that you've been on this webinar for 2 hours, and so we're going to be proceeding quickly with the questions and answers and as Suzanne said, wrapping them into the final comments. So with that being said, I'm going to bring forward a few of the questions that we've received in the chat box throughout the session, and you know, invite any of the speakers to address them during their final remarks. First, the speakers on this call have made clear the urgency to end unilateral coercive sanctions. US activists and even members of the public would find these points very compelling. However, many feel powerless because they lack resources on how they can participate in a movement to end sanctions. What are some practical, concrete actions or campaigns that activists and organizations can take on a local level in the US, within the categories of legal fights, media campaigns, and direct actions or beyond? And I want to leave that for the speakers, but I do want to comment here that one campaign that's going on is called Sanctions Kill, and you can visit their website at sanctionskill.org. The NLG is an endorser of that campaign, and so is the IADL. And this is an organization, this is a campaign that's kind of organizing grassroots activism around this issue, but I know our speakers might have a lot more to add to that conversation. The second question that we received several questions from a few people, and so I'm just going to kind of condense that into one, which is that the United States government routinely and flagrantly violates domestic and international law. And so is the legal, you know, and we can look at, you know, broken treaties with indigenous peoples in the United States, the creation of Jim Crow law and the continuing institutionalized and systematic racist oppression in the United States. And so is the legal system just a system of rationalizations to support corporate power? And if so, how can we use the law to fight back? And finally, are the decisions made at the International Criminal Court enforceable in any way? Because if there isn't a mechanism for enforcement, what happens when there is a decision against unilateral coercive measures? Is the UN powerless to enforce this given the power and dominance of the United States? And so what would folks recommend as the way forward within that context?
Okay, and I'm going to just add briefly then 2 questions that were directed to specific people. The first to Roger. Roger, the question is, why is a small landlocked country like Zimbabwe so important to the US and the UK? And a question for Raji. Raji, the question reads as follows. The UN projected that Gaza would be unlivable by 2020. In your opinion, would this have come to pass without COVID-19? And have you any idea how many sets of COVID-19 PPEs have been able to enter Gaza? A PPE is personal protective equipment used to protect people from the virus. I think those are all the questions, and who'd like to start with either answering all of them or one of them, or just giving a brief closing remark?
Would we like to do it in the order that people spoke in? Micol, would you like to do your final comments?
What should I say? Thank you very much. It was very interesting to hear from the ground, people, what they are living. What can I say? What can be done? I don't know. I'm working at the UN, so I would suggest to follow up the work of the United Nations. As you see, there are a lot of resolution. It's not just paper. To have this kind of resolution, to obtain a condemnation of unilateral sanctions, it takes a lot of time, a lot of work, a lot of advocacy work, and this is always the results of a lot of advocacy work. What is happening is that the UN are always discredited, especially by the US and other Western countries, who said the UN is useless. And then they do this exactly because of the contrary. The UN in theory is a very powerful institution. It's true that they cannot enforce, but through dialogue and cooperation, they obtain huge results during the years. And states within the United Nations always say things quite extreme, things that they wouldn't say at national level, because they know that the United Nations people are not looking. I mean, all the principles we mentioned that make unilateral coercive measure illegal are in the charter. And the charter of the United Nations is our charter. Is we, the people of the United Nations, we committed to all that principle, to save succeeding generation from the scourge of war, to promote human rights and development, etc. We, the people, committed to this, and we gave mandate to our government to do everything is contained in this charter. Then, if the governments don't act as they should, it's our work. You know, it's we need both political work, lot of political work, to make at least states politically accountable for their violation, even though it's more complicated to hold them accountable on a legal point of view, especially for violation of international law. But the two struggle must go together, the legal battle and the political battle, just to obtain implementation of the charter. And the UCMs offer as a good opportunity to work on all the principles we established 70 years ago. This would be my suggestion.
Thank you so much, Micol. Nina, would you like to add your closing comments as well?
Sure. Thank you again to everybody who participated. It was a great panel. I'll answer. There were two questions. There was one about how to respond, how to fight the sanctions as people located in the US. And then the second question was about, the role of the law, whether the law can play a productive role or not, a radical role or revolutionary role. The first question, I think there was some momentum building toward fighting the sanctions and fighting against a potential war in Iran in the early part of the winter, and actually all the way up until stay-at-home orders were coming down in the US. There was an action planned in mid-March that was canceled because of the quarantines. So momentum is really building in the US to participate in street demonstrations. There are also lots of petitions that have been going around. There are waves of petitions directed against the US government, some legal petitions, some not, some activist petitions, some petitions organized by Iranians that are broader, petitions that have been signed by both people in Iran and the United States. So these are things that are happening. The spread of the virus has made it difficult to do real organizing work and has sort of slowed the momentum. But I will say that an organization called Red Nation, which is it's an indigenous organization. It's a left indigenous organization that has chapters across the country, has taken up the sanctions issue. They have an anti-sanctions campaign, and their analysis is interesting. It's that the US is now one of the biggest, if not the biggest, exporter of oil in the world. It's high up there. And one of the reasons is that they have used the sanctions to destroy the ability of Venezuela and Iran to export oil. And by doing so, have opened up the market for American oil. And that oil is coming from indigenous land. Indigenous land is being, in the US, is being exploited, which is why you had the DAPL protests several years ago, and there are protests raging throughout Canada as well. So Red Nation is one institution that I think it's important to watch. Code Pink has a renewed anti-sanctions, anti-war campaign. They just did a big webinar last week. And then some people who are actually on this call are about to launch an Iranian solidarity, an organization that's going to be standing in solidarity with Iran, an anti-sanctions, anti-war organization. And that will be a more broad-based organization that's not going to be identity-based. So once we go public, people can join that as well. In terms of the usefulness of the law, I'm very critical of the law. That's part of the reason why I left legal practice. But I would say that the law, in concert with social movements and street protests and all kinds of other activities, has been effective. It's been effective in the US context for sure. That's what my research is about, but it's also been effective in other parts of the world. So I think the law is most effective when people work across borders, when people get strategies and tactics from other parts of the, lawyers and legal organizations from other parts of the world. American lawyers have been most effective when they've worked with lawyers from across lawyers and activists from other parts of the world. So the law certainly has its limits. But it exists, it can be used as a tool, and after the revolution happens, for those of us who believe in revolution, if you're not an anarchist, then we need to have a legal system. So we can't just dismiss the role of the law. Law exists no matter what society you're in. It existed in Soviet Russia, there's a law in Cuba, there's law in Iran. I mean, law is important, it exists, and we need to contend with it if we want to change the world. That's my position. That's it.
Roger. Oh, sorry. Did you want to add something? Okay.
One, I thank the presenters. I thought they were I thought they were excellent. And these questions, I just very quickly go through the questions. One, the importance of Zimbabwe. Zimbabwe is important. And why it's so important to the West is that Zimbabwe represents the bad example that it was always their worst nightmare, of an African country that took its land back and gave it back to the people. And it's not the Zimbabwe question, it's the Southern African question in other parts of Africa as well. And since the thrust of capitalism is to control and exploit resources, that's why Zimbabwe, they have to make an example of Zimbabwe as that we will knock you out the box, anybody else who's thinking about it. So that's one. Two, we're part of the Sanctions Kill program. I think we have to combine what you do legally in the street and what can be accomplished legally can really only be determined by the strength of what's going on in the street. So there's, as Nina just laid out, there's a dialectical relationship to it. Three, like I said, one of our tactics that we're dealing with around the Zimbabwe sanctions is the question of, pushing the Congressional Black Caucus, who ostensibly should be representing the interests of Black folks, to at least create that pressure inside of the electoral arena. Fourth, the UN, which we learned from the Cubans when we first went there in 1989, is valuable as a place for international propaganda to get the world to know what your issues are, because in the country within which you reside, they're not going to present that to you. So I think it's very important for that and to capitalize on that. And fifth, long term, Father Miguel Escoto Brockman, who was the foreign minister for Nicaragua, made a proposal back in 2012 called Reinventing the UN, how to make the UN a functional organization capable of dealing effectively with the great 21st century challenges confronting Mother Earth and humanity. People should read that. And he talks about democratizing, that the General Assembly would be different than the Security Council. And the Security Council would not have permanent members. It would be represented in the same proportion as populations are in the world. So people should, and he talked about moving it from New York to Dar es Salaam, Tanzania. So it's just us looking outside the envelope in terms of then how do we move forward long term. Thank you.
Thank you for that, Roger. Cristóbal, Cristóbal, would you like to answer some of those questions or give some last remarks?
Maybe just invite everybody to join the sanctions kill campaign. We think it's the right advocacy action right now due to the quarantine. Thank you.
Thank you very much. Marty?
Yes, I also concur with participation in the sanctions anti-sanctions activity, but I actually think the most important thing that we can be doing is educational. That one of the reasons that human rights are so flagrantly violated in the US, and now we can see that the denial of the right to health care is in the US, the way the US operates towards all these other countries that it's levying sanctions against, it does to the people who reside here as well. And I do think that people in the US are going to come out of this pandemic with a different view of the role of government, of neoliberalism, of the relationship of peoples to each other, and the importance of cooperation. The question is how we can bring to the attention of as many people and organizations as possible the violence that's done by unilateral coercive measures, and why that has to just be completely discarded as any part of US foreign policy. But I do think that the main focus should be on education, because I don't think you can make the legal changes unless you have the social movements that are well educated to support the legal change. And that includes going to the UN Human Rights Council, being involved in the various ways we can as organizations working across borders to embarrass the United States into changing the ways in which it interacts with the other nations.
Thank you, Martin. And lastly, Raji?
Yes, thank you. First, I think we have very simple choice, either rule of law or rule of jungle. There is no other alternative. And definitely, I mean, we are fighters for rule of law in this world. And that's something, I mean, we are aware of it and we are practicing it. And we witnessed in the last 20 years who is really attacking severely the world order, the international law, international humanitarian law, and the human rights. Who is threatening the ICC boldly and at the daylight? The president, the foreign secretary, and the other people in the U.S. administration, like John Bolton when he was the national security advisor. So there is, I mean, really strong attack on the international law, international humanitarian law, and the human rights, and they want to impose their own views, which is rule of jungle, as simple as that. Like I said, I mean, in all blockades, I mean, they are having, and many other issues, the international human rights organization, legal organizations, have very clear, simple point of view against what they are doing. It's not only the suppressed and the oppressed and those who are affected by the policies, but the problem, I mean, that there was no political power countering that. So we have to be more affirmative about the rule of law position and the call for it, and try to have it as much as we can and make our voice clear and sound, I mean, in this regard. Second, regarding what we are having in Gaza, I mean, you can simply go to PCHR website and look to updates on this regard, but we have nothing almost. I mean, we have about 30 extensive care units, I mean, for the entire Gaza, and we have like 100 systems, I mean, to respiratory system and so on. So if something, I mean, happens here, real disaster will be in Gaza, and that's because we have no freedom of movement for goods or individuals. Not now, but as I said, I mean, before, for the last 14 years, international law, international humanitarian law, and precisely Geneva Conventions are there to protect civilians at the time of war, but nobody, I mean, cares about this really crime going on. So the situation in Gaza, very, very fragile, and I hope it doesn't hit hard here, otherwise it will be disastrous. In the West Bank, relatively, things maybe 10, 15, or 20% better, but still, I mean, situation very uncertain, and you know, Israel till this moment very, very discriminatory in this regard, and if they pay any care about what's happening in Gaza, for example, they pay care for one thing. They know it will affect them sooner or later, and that's if they care. I mean, they care for this reason only. Once again, I don't think ICC almost in a freeze, and for the last 15, 20 days, they almost don't answer any questions. I mean, everybody, I mean, work remotely, and but we were supposed, I mean, to be back, I mean, to the court on 29th of April, but I think all schedules are cancelled by now, and everything will be postponed for months till this, I mean, thing of COVID-19, I mean, be relatively controlled, or having a recipe to get rid of it, hopefully, I mean, one day. Keep well and keep safe, and keep the work, keep the good work, keep the strategic optimism. I think, I mean, all of us, we are on the right page of history, and one day, I mean, we will overcome this. But we have to keep collectively exchanging views, raising the questions, try to find answer, and not to make the evil be in control or use this COVID-19 for bad reasons. Thank you.
Thank you so much, Raji. And thank you to all of our speakers, and thank you for everybody who joined us today for over 2 hours of discussions. And we look forward to future discussions. We just wanted to remind you that Charlotte added some links in the chat box, which includes a link to the Red Nation, as Nina mentioned, to the Sanctions Kill campaign, and to both the IADL and NLG International Facebook pages, so that you can go to those sites to find out what will be sort of future efforts to mobilize against the use of unilateral coercive measures. So thank you, everybody, for your work.
Thank you all.
Okay.
Yes,
Bye.
thank you again. And we look forward to hosting future webinars of this type as well. We will send an email to all of you who participated today with links, with the same links that we talked about here, and with additional information. And we look forward to inviting all of you to our next webinar following up on this discussion and furthering our efforts to bring an end to unilateral coercive measures. Thank you again.
Bye-bye.
Bye.
Bye, Micol. Bye.